Hello everyone. So let's look at another very important topic on anticipation. And under this particular topic, what we are try to appreciate is the number of prior art references which can become novelty destroying, as a result of which the patent application that has been filed may not get granted. In simple terms, anticipatory documents are the ones in which the subject matter of the invention is being seen as such, meaning if let's say a patent application is being filed for the invention covering ABC, then the anticipatory document that also has an ABC would be a novelty destroying document. So in anticipation, the patent office examiner is trying to look at or discover all the prior art references which can be novelty destroying only. So he is not looking at multiple references, he's looking at those documents in that one single document. All elements of the claims of the invention are found. Okay. So the relevant sections for anticipation are section 2(1)(l), which is where new invention, the term new invention has been defined. Section 13, which is on anticipation per se, and then sections 29 to 34, which is on the exceptions to the anticipation, which means that there could still be certain prior art references which may not be considered as novelty destroyers because of certain specific reasons that we are going to study. Okay, so section 2(1)(l), we discussed it during the class as well in quite in detail. What does it mean? So new invention, if you look at the term per se, this is directing us to the kind of inventions which have never been uh, there in the world before, whether by way of publication or by way of its use, which means nowhere else, either in this country, which is India, or anywhere else in the world, have they been anticipated. Meaning this invention is absolutely new. So we as India follow the norm of absolute novelty, where if you are filing a patent application in India covering whatever subject matter, that subject matter should not have been published before uh, when you were filing a patent application, or should not have been in use. Now, publication, whether it could be before or later, that is another area that we are going to discuss in the subsequent sections. But overall, in one single brief summary, if I were to tell you, section 2(1)(l) is talking about those kinds of inventions which are absolutely new, both in India as far as any other city or state is concerned, absolutely new in India, and also new with respect to anywhere else in the world also. These have not been seen, known, published in any part of the world. Okay. Now, section 13 on anticipation has three subsections, or maybe largely two subsections, which are the key or the important ones. Section 13(1)(a), then section 13(1)(b). Okay, these two, followed by section 2. Okay, these are the ones that we need to really read when it comes to identifying what could be the possible prior art references that examiner may highlight or specify in the first examination report that the patent agent would receive on behalf of the client. So he will mention whether it's a 13(1)(a) document or 13(1)(b) document or 13(2) document. Okay. So these lingos as to which kind of a prior art is covered in which particular subsection of 13 is what you should be knowing. And then there are section 13(3) and 4 also, which we will do later. But let's right now focus only on section 13(1) and section 13(2), and within section 13(1), let's focus on its further subparts, which is divided into A and B. So if you read, I think before you go through this particular slide and hear me out on this, it's important that you um, pause this video and read section 13(1)(a), section 13(1)(b), and section 13(2) at least twice. Okay, and then you will be able to appreciate as to what the interpretation of these section and subsection is. So consider, in order to understand section 13 well, consider there is a patent application P which is claiming subject matter Z, and this is being examined by the patent office. The examiner is looking at the prior art references which could identify, or which wherein he could find subject matter Z already, so that your patent does not get granted, because that's his job. He cannot keep granting the patents for the inventions which are already known in the world or already known in India. So he has to make sure, that is, he has to make all bona fides, he has to make all due diligence to ensure that he identifies any prior art reference that can showcase that subject matter Z already existed. So when you read section 13(1)(a), this is talking about prior published patent specifications which are filed in India on or after 1st Jan 1912. That means anything that I have highlighted here in bold and underlined, these are the keywords to understand what section 13(1)(a) documents must have. So section 13(1)(a) document should be the one which is already published, which means it was there in the public domain before the patent applicant P filed for the subject matter Z a patent application claiming Z. These prior published documents should only be the patent specifications. We are not talking about any other kind of prior art reference, whether it's journal articles, thesis, opinion papers, or anything. This section 13(1)(a) is specifically talking about very specific type of prior art document, which is where they are prior published. These are the patent specifications only filed in India. So filed in India, it's not talking about any other foreign filings here. And these are the ones which have been filed on or after 1st Jan 1912. Now the reason why the threshold of 1st Jan 1912 has been specified, why not, one could question as to why not those patent documents which were filed before 1st Jan 1912, because even those, even if the patent had claims and it had expired, um, by the time as we are speaking in today's year, it still remains to be a prior art, no, because that's something which is already published, so you can't reclaim it. But the threshold of 1st Jan 1912 is still kept because it is very difficult to identify the prior art references which were filed before this date, because that time it was not seen 18-month publication as a mandate. There was no good documentation that was available. So basically it is very hard to find out all those patent applications which were filed before 1st Jan 1912. That is why this particular timeline has been kept. So section 13(1)(a) documents, very specific ones that your examiner is looking at. Now let's look at section 13(1)(b) document. This is the patent specification which is filed in India. So again, just like the previous one, uh, these are the patent specifications only filed in India, which claim subject matter Z, having an earlier priority date but were not yet published when patent application P was filed, which means the common denominator between section 13(1)(a, section 13(1)(b) documents are, or the common denominator is that both are referring to a patent specification, both are referring to these patent specification filed in India, both are referring to the patent specification filed on or after 1st Jan 1912. However, the key distinction between the two is that in 13(1)(a) document, these are the ones which were already in the public domain, which means these were already published when, let's say, I, Sheetal Chopra, was filing my patent application covering subject matter Z. That means when I was doing searching before I could file a patent application, I would have anyway found prior published document patent specification under section 13(1)(a). So if there was already a prior published document and I'm still filing a patent application, it is one, it shows that I'm not bona fide. It's already something which existed, and if patent office has found it, number one, I should not have filed the patent application, and even if I have done, then the patent office would reveal this document to me and say that Sheetal, patent cannot be granted to you because there is a prior published patent specification filed in India or after 1st Jan 1912 as far as section 13(1)(a) is concerned. In 13(1)(b) what happens is that when I was filing the patent application, this particular patent application, which has now been picked up by the patent office in the first examination report, was not in public domain. Okay, because you know that every patent gets published in a span of 18 months only. Just at the expiry of 18, not before the expiry of 18 months. It cannot be published. That means when someone else filed a patent application and 18 month is not yet over, if I end up filing my patent application somehow covering the same subject matter, then I would not have known about that patent specification, and hence I ended up filing it in the patent office. These kind of documents are called as secret PRARA documents or hidden PRARA documents. It doesn't mean that someone has secretly done anything. It is just a matter of chance that I ended up as an inventor, I ended up, or you as a patent agent ended up filing it during this 18-month time period when that anticipatory prior document was not in public domain. The key feature of 13(1)(b) document, which is the second one that we are talking about, it is a patent specification must have been filed in India only, which must claim the subject matter Z, okay, and should have a priority date earlier than the patent application's priority date that I am filing, which means the inference is that if there is a prior document in which uh, the subject matter Z, which I am trying to file, is not claimed but only disclosed, and if that came out or emerged to be a secret or a hidden prior art document, then I will still get a patent because it was not claimed. Okay, so claiming is one of the key parts of section 13(1)(b). Now next let's come to the third and the last type of the prior art document which patent office would try to discover. These are again the prior published prior art references in India or anywhere else in the world, such as patents, patent applications, journals, articles, opinion papers, research theses, newspaper articles. It could be anything, okay, which was not already specified in 13(1)(a) or 13(1)(b). So that means while in 13(1)(a) and 13(1)(b) we are only talking about the patent specifications filed in India, in 13(2) we are talking about not just the patent applications but also any other kind of a patent application or any other kind of a patent prior art reference which may have been filed in India or anywhere else in the world. Okay, so this is in summary about what section 13 talks about. In order to understand section 13(1)(a), just to re-summarize, it covers already published Indian patent application filed on or after 1st Jan 1912 as prior art that discloses and or claims the subject matter claimed in referred patent application. So if I as an inventor filing a subject matter application covering Z, then 13(1)(a) document should be having the same either in the disclosure or in the claims part. In that case, if 13(1)(a) document is found by the patent examiner, my patent application will not get granted. Therefore, essentially 13(1)(a) document does not cover any published Indian publication such as your journals, thesis, newspapers, articles, anything that discloses the subject matter of the referred patent application, meaning this is the patent application about which we are talking, which is being examined by the examiner. Second, it does not even cover the foreign patent applications that discloses and or claims the subject matter which we are trying to seek a patent on. Let's go ahead on section 13(1)(b) document. In order to understand it, just to re-summarize, this is the document which is again the Indian patent application which has been filed in India claiming the same subject matter and not just simply disclosed, but it is still covered. It was hidden to me because it was not in public domain when I was filing it. As an example, consider a complete specification which has been filed in India on 1st Jan 2020 by some Mr. X. It was published on 1st August 2021 and it claimed the subject matter Z. So why 1st August 2021? Within a period of 18 months it is showing that it got published. Now Mr. Y filed a complete spec claiming the same subject matter Z on 1st Jan 2021. Now look at the date. 1st Jan 2021, this patent application of Mr. X was not in public domain because that came up only in August. So Mr. Y had no chance to know that some Mr. X has already filed a patent application having an earlier priority date than him when he filed it at the patent office. So therefore this complete specification of Mr. X was a hidden prior art for Mr. Y. Okay. In this case, Mr. Y patent would not be granted because this hidden prior art reference claimed exactly the same subject matter as that of Mr. Y's patent application. In the other example, consider the same complete specification which was filed in India on 1st Jan 2020 by Mr. X. It was published in 18 months, 1st August 2021. This particular reference did not claim, but simply disclosed subject matter Z in description. Now, in this case, Mr. Y's application, which was filed within this time period of 18 months, will get granted, and Mr. X hidden prior art reference, which was picked up by the examiner under section 13(1)(b), will not be considered as a prior art document because the subject matter was only disclosed but not claimed. So claiming is a very important aspect of section 13(1)(b) documents. Okay, I hope this is clear to all of you. Let's move ahead. Another illustration. So essentially, section 13 does not cover those hidden prior art references that were filed in some foreign country because filing in India is the key. These should be the ones which are filed in India. So section 13(1)(b) documents we are talking about. Imagine a patent application was filed in Korea on 1st Jan 2020, which got published in 18 months time period, which is 1st August 2021. This claimed and also disclosed the subject matter Z. Now if Mr. X has filed a patent application in India claiming subject matter Z on 1st Jan 2021, which is during the time span of this 18 months when Mr. X document which he had filed in Korea was not available, then this Korean patent application would be considered as a hidden prior art document. I'm sorry for the typo here, not the proper art, the prior art. Please read this hidden prior art document. Okay. So in this, the Korean patent application is not being considered as section 13(1)(b) novelty destroying prior art because this was the document which was not filed in India. It's a foreign document which is not covered in section 13(1)(b). Now, can this Korean document be considered as novelty destroying document under section 13(1)(a) or section 13(2)? Now, however, this is not considered as novelty destroying document either, even as per section 13(1)(a) or 13(2), because these two sections are about already published documents. Okay, in India or anywhere else, but not the ones that were hidden. So this Korean patent application would not even fall under 13(1)(a) because 13(1)(a) documents talks about prior published documents. Similarly, this Korean document would not be even considered as a prior document under section 13(2) because section 13(2) should also be such prior publications which were there already in the public domain before the inventor, some other inventor, filed a patent application covering the same subject matter. Let's go ahead. So take home messages according to section 13 to qualify the test of absolute novelty. The invention or claimed must not be anticipated by any prior art reference which was previously published in India or elsewhere, which is covered in section 13(1)(a) or 13(2), and it should not be there as a prior claiming. I mean, somebody else should not have filed it in the patent specification claiming the same subject matter as a secret prior art, meaning it should not be covering, it should not be covered in those patent application which remained hidden when this inventor was filing it. And section 13(4), if you reread, now you can stop it here, pause the video for a moment, go and read section 13(4). So section 13(4) talks about that even after this entire scrutiny has been done by the patent office for many years, let's say it took, let's say 3 to 4 years for a patent to get granted. This granted patent may still not be considered as presumed valid. This is the only, I think, law in our country, India, which is distinct from other parts of the world. At least in US, it doesn't say. There in the law, it says these are presumed valid, considered as presumed valid uh, patent, which means in the court of law, when there is an infringement action that has been taken place, where an inventor or a patentee has taken someone in the court, there is a lot of burden on the patentee to show that his patent is valid, as against a bigger burden on the defendant, meaning the one who was infringing, to show that the patent is invalid. So it totally shifts the burden of proof depending on whether your particular law of land is um, identifying that granted patent as presumed valid or not presumed valid. So what are the remedies then in case of anticipation? If let's say there is a there are certain prior documents which have been identified by the patent office, either under 13(1)(a), 13(1)(b) or 13(2), what is the course of action that can be taken care of? So under 18(1), okay, we are reading 18(1), which has further two subclauses A and B. So under 18(1), the controller, if he identifies any of the prior reference that we have just spoken, he will then refuse the application, of course, because there is something which is already anticipating that invention, unless the applicant does either of the two things. What? He either changes the specification, he changes the claims to shift from seeking claims on Z to Z dash, meaning he has to make some amendments to come out of the prior art reference. Or he has to show that, Mr. Controller, my priority date, the priority date for my patent application is earlier than the priority dates of the documents that you are showcasing as novelty destroyers in the examination report. Either of the two things would have to be done by the applicant to be able to overcome section 13 objection, and if he doesn't do it, then the patent cannot be granted. Now further ahead, section 18(2), it talks about that whenever there is a hidden prior art which has been identified by the examiner, by the controller, then of course, though that hidden prior art, since it remained to be hidden from the patent applicant, he will make this patent applicant to introduce that prior art, hidden prior art documents reference to be included in his own specification. So the specification shall be, so reference to that other specification shall be inserted by way of notice to the public in the applicant's complete spec, unless within such prescribed time he does the same thing as we just discussed. Either he changes, he makes amendments to his patent application, or he proves that he has an earlier priority date. Okay, so patent anyway is not going to get granted, but for the hidden prior art references, he is going to ask him to include the reference also. Okay, now let's go ahead. There is rule 29, which says that in case of anticipation by prior claiming in the documents which are 13(1)(b, that is the secret documents or the hidden prior art references, the controller may postpone the grant of the patent and allow a period of 2 months for removing the objection. So here he is giving the opportunity to the applicant कि भाई you take 2 months more and you please make changes, make amendments, या तुम ये show कर दो that you have a priority date earlier than the priority date of the document that I am showcasing to you. Then you also must read Rule 30, which talks about hearing. That before the controller decides anything, whether he is happy with what applicant is giving the reply or not, whatever he wants to do, he cannot do it unless he gives hearing to the patent applicant. This is called as the legal maxim, legal principle called audi alterum partem, meaning if there is any untoward or adverse outcome that is expected, anticipated, then hearing must definitely be given. I mean, the controller must definitely hear the other party before he decides. So that hearing would take place. And after hearing or without hearing, if the applicant has not attended the hearing, let's say, or he has notifies, if he has notified that he doesn't want to be part of the hearing, controller may specify or permit such amendments to the spec as will be to his satisfaction to be made, and may direct the reference to such other specification to be introduced. So this controller will tell you, Acha, theek hai, you are not making the amendments. I am suggesting you that if you make these amendments, you will be out of the prior art document, prior art reference that I am quoting. So either ways, whatever is happening, the controller is giving the applicant the opportunity. He is hearing the patent applicant, but finally the grant will not happen. There could be reference to the prior art reference that would have to be introduced unless this patent applicant either amends his application or shows that his applicant's priority date is earlier than the date of the prior art document revealed by the patent office. You must also read Rule 31 and 32 along with it, because this talks about the form of reference to another specification. So this is how reference is introduced in the applicant's complete spec. It says reference has been directed in pursuance of section 18(2) of the Patent Act 1970 to the specification filed in pursuance of application number so and so. ठीक है, तो ये इस तरह से reference is included. Rule 32, which is about procedure in case of potential infringement, which says that if in consequence of an investigation made under section 13(1), and 13(1) has both kind of documents A and B, if it appears to the controller that applicant's inventions cannot be performed without substantial risk of infringement, the applicant shall be so informed and the procedure of Rule 29 shall follow. It shall be applicable. So basically what he's saying is that if he has revealed the patent document or any patent specification which he thinks that if tomorrow the inventor's patent application gets granted, or let's say he starts to manufacture the same subject matter Z which is already claimed in someone else's patent specification which are already granted, let's say, then in case the patent is granted it would amount to be a infringement. So he is basically letting the inventor know don't do this activity. Okay, so therefore he is making the entire scoping of having these documents reference introduced, or he is telling that make changes to your patent document or at least show that you have an earlier priority date. Okay, so he's helping you in this case. So this is what you should follow, and then let's go ahead. So section 18(3), this is talking about that if as a result of this investigation that examiner has done to identify prior art documents, and that invention so far as claimed in any claim of the applicant's complete spec, if he finds any section 13(1)(b) document, let's say, है ना? No, sorry, section 13(1)(a) document. 13(1)(b) we've already spoken. Now let's talk about that he has identified section 13(1)(a) documents, which is these are the documents which are already there in the public domain. Then also in that case, And so there are two conditions. One, he has one found section 13(1)(a) document for you, and that such other section 13(1)(a) document was published on or after the priority date of applicant's claim. है ना? So a little change here. In 13(1)(a) we have already always talked about prior published patent documents, patent specifications. But here there is a little twist where he is saying there could be sometimes an instance where 13(1)(a) document was not in public domain. So you can't still call it as a secret prior art, let's say, because there is a very specific non-publication date that he is referring to, which is these were um, the 13(1)(a) documents which were published on or after the priority date of applicant's claim. है ना? So then what will happen? So in a sense, a little bit similar to section 13(1)(b) document, but in this case, the specific threshold that is being shown is that these were published after the priority date of applicant's priority date. In that case also the same principle shall apply. He will either ask him to change, amend the parent document, or he will ask him to show that whether the inventor has earlier priority date if at all, or and also ask him to include a reference and not grant a patent until the time he is satisfied. The controller is satisfied. So let us look at some illustrations. Before that, in brief, section 18.3, let's consider in order to appreciate what 18.3 is talking about. This is about, let's say, patent application A, which is being examined. Patent application A covers the subject matter X, let's say. Under section 13, examiner makes investigation and reveals prior art document. And this prior art document, let's say, is referred to as prior art 1, which was published on or after the priority date of patent application A. ठीक है, इतना बात समझ में आ गया आपको? Now, prior art 1, what is that prior art reference? This also covers the subject matter X. This is the patent application which was filed in India on or after 1st Jan 1912. Hence, it is referred to as section 13(1)(a) document. And this patent application A now, should patent applicant for the patent application A must show that it has same or earlier priority date than that of the prior art 1, or he amends his specification, failing which the patent will not get granted, and a reference could also be asked to be made by the controller. Let's understand this by three different illustrations. In the first illustration, let us consider that the inventor has a priority date of 1st Jan 2022. He files a patent application A using this priority date. The provisional patent application files a complete spec within a span of 1 year by 1st Jan 2023. It gets published in 18 months, which is by 1st July 2024, and it claims a subject matter X. In the first examination report that he receives in year 2026 after 2 to 3 years, he finds that examiner has quoted prior art 1 document, which is section 13(1)(a) document. Now he is now analyzing what is this document all about. This prior art A has a priority date of 1st Jan 2023, which, as you can see between the two, parent application A and the prior art reference, the prior art reference has a later priority date, but still it has been picked up by the examiner. Okay, let's see why did he pick up. Because this prior art document, which is a complete spec, it was filed within 3 months. ठीक है, तो quickly it got published. So the complete spec was filed within 3 months, much before 12 months period was going to get over, but that is by 1st March 2023. And then this prior art 1 Form 9 was filed for early publication, and hence it got published by 1st May 2023 already. This also claims subject matter X. That means if you look at 1st May 2023 and you look at the publication of the document or the patent application which is being examined, which is 1st July 2024, this document is already published in a way, है ना? So even if it has a later priority date, but it was a prior published document. This was published post the priority date, of course, of the patent application A. So what was the priority date? 1st Jan 2022. When was prior art A or prior art 1 published? 1st May 2023, which means it was published post the priority date. But therefore it has been still picked up as a prior art reference under 13(1)A because it was there in the public domain when this was being examined. So the options for the patent applicant is what are the options that he has? Either he amends to claim X dash or some other thing, or prove that it has an earlier priority date. In this case he cannot prove, or does he? Yeah, he in this case he can prove that he has an earlier priority date. So he doesn't have to amend his specifications. Or else his reference, this reference for prior art 1 could be added, could be asked to be added. So in this case, patent application A should get granted given that it has a priority date earlier than the priority date which was highlighted by the patent office. He has a priority date of 1st Jan 2022 while the patent office picked up the prior reference that had a later priority date. Let's understand this a little bit more using illustration 2. In this case, let the same facts exist, a little bit different here in terms of priority date. Let's say priority date of this patent application is 1st Jan 2023, which was published on 1st July 2024, which is 18 months, and first examination report was received on 1st Jan 2026. Then patent examiner highlights prior art A or prior art 1, which has a priority date of 1st Jan 2023, the same priority date. See, both have same priority date. Prior art 1 was published by 1st May 2023 through early publication, which means when the patent application was published on 1st July 2024, this prior art document was already there in the public domain. And then it claims the same subject matter X, and this is a granted patent, let's say. Prior art 1 is a granted patent, 13(1)A document, granted on 1st Jan 2024. So what are the options for the patent applicant? Either he amends it to claim X dash, or he proves that he has earlier priority date, or at least not the priority date later than the date of prior art 1. Either he shows he has a priority date earlier or at least not later. It could be same. In this case, both have a same priority date. So what does it mean? Should both be granted? We both have a same priority date. No one knew each other's claims. Who is filing what? Both of them came up with the same invention independently. It might happen. Now in this case, when both documents come to him, since prior art 1 is already granted patent, it's difficult to still receive the patent for the later one, for the patent application that is being investigated. A little weird case, I should say. These are very rare instances where the same priority dates are there and um, one is granted, other one is not yet being examined. But also this might happen that prior art 1, let's say it is not granted. Both are in the application stage, है ना? Then in that case, what will happen? To whom would patent office grant a patent? That's a question. It will get granted to the one. Uh, so first thing is it cannot be granted to both. Otherwise, there will be a case of double patenting. And imagine if that happens, then what will happen to a licensee? Where will he go? Whom will he ask the license from? To patent applicant 1 or the prior art reference owner 1? So both cannot get granted. Only one will get granted. Only to one the patent application will get granted as a patent. But to whom, that's the question. So in this case, he will ask both the parties to mutually decide who wants to get a patent. They want to sign up an MOU. They want to say, "Acha, theek hai bhai, you take a grant, and but whatever you do with your invention, pay me some amount as royalty or something. Some kind of a mutual agreement." Or they collaborate in that sense, or they become uh, co-owners to the same patent. to one patent only that gets granted. Whatever could be the method of, agreement between the two, that totally depends on them. But one has to agree that, okay, it gets granted to either of the one. But if both do not agree, then if there is a dispute, then patent office might want to look at who invented it first. So he might ask for the lab notebooks. That's a little bit more of an intense investigation. Um, but like I said, these instances are very rare. Let's go to illustration 3. So what I just said, in illustration 2, only one would get a patent and not both. Illustration 3, consider that the patent application which is being investigated prior art has a priority date of 1st Jan 2023, which was published on 1st July 2024, which is within a span of 18 months. This claims a subject matter X, and first examination report was received on 1st Jan 2026. ठीक है? Then patent office highlights or suggests prior art 1, which has a filing date of 1st September 2022. Let's imagine that here the priority date, the priority document is a complete specification. Okay, it was published early, which is by 1st Jan 2023, maybe because the applicant had filed Form 9 for early publication. And it got early granted also within a span of 1 year, 1st Jan 2023, 1st September 2023. Let's say this is a startup and utilize the provisions of Rule 24C, where expedited grants could happen, and it claims subject matter X. Now, in this case, if you look at both, the patent applicant's priority date for his application is earlier. Oh no, it's later than the priority date of the prior art 1. He has a priority date of 1st September 2022. The applicant's priority date is that of 1st Jan 2023. है ना? So now what happens? So if you look at both, see one interesting thing that you see, that the priority date of 1st Jan 2023, when patent applicant was filing his patent application, that is exactly the date when prior art 1 was published. देखा आपने? So if you look at 18.3, it talks about those 13.1a documents which were published on or after the priority date of the patent applicant A. So this is the exact that one which is published on the same day as that of the priority document. Now what are the options? So either he amends his specification to claim X1 or X dash, or proves that he has an earlier priority date, where in this case he does not have. So he will have to amend it, and he may be asked to get a reference added to prior art 1. So in this case, patent application A cannot be granted unless he amends it finally to the satisfaction of the controller. Now another, we have reached to the second part. So part A thankfully is is now covered. Uh, Now let us go to exceptions to the anticipation. This is equally, why did I say thankfully? Of course, one must be in gratitude all the time. Uh, but more specifically, this thankfulness came out because it's not otherwise easy to explain this anticipation section. It's very difficult because if you read at the language, it's so tough. So it took a little while to understand, given that I've been teaching since long, and there is a book. It's a grace that I could appreciate and understand it. But I'm more than happy if any of you wants to really understand it a little bit more. If you have a little bit different understanding as to what I have understood it, and in this way as I've explained, but I'll be extremely happy if you can come back to me and to let me know if there is some change which is required in understanding as far as part A of this presentation is concerned. Okay, let's move ahead. Exceptions to the anticipation. Okay, so this is talking about the prior art references, which even if they are the prior art references would not be anticipatory, meaning parent office would not consider them as novelty destroyers because of certain reasons. Now, first reason is quoted in section 29, subsection 1, wherein he is talking about those prior art references which were published or which were filed in India before 1912. Like I said, why? Because in order to identify such prior art documents is one very difficult. 18-month publication was not a norm then. There were no databases to identify such. So nobody knew what exactly was filed before this date. And hence such prior art documents are not seen. Okay, these are not novelty destroyers. Number one, these are not even been searched. Then next is section 29(2), which has further two sub clauses. So section 29(2) subclause A, which is talking about the published documents which were published before the priority date of the applicant's claim. है ना, मतलब these were already published and covered the same subject matter, and that matter was published uh, by obtaining it from that inventor, ठीक है, or from the person through whom he derives the title, and was published without his consent. तो ये and है दोनों में, मतलब it was first obtained from him, मतलब उससे लिया गया वो document या उससे वो लिए गया सारा content, and thereafter it was published without the consent of the person from whom it was obtained. So the matter from whom it was obtained, that person could be a true and first inventor. That could be a entity, the employer of the inventor. It could be a university, institution, whatever. है ना? तो when somebody obtains that invention from someone and then publishes it without the consent of that person from whom he obtained, then in that case these documents will not be considered as anticipatory, provided the patentee or the applicant, है ना, जिससे obtain किया गया, from the person from whom it was obtained, they went ahead and filed the patent application as soon as they got to know कि किसी ने गफलत किया है ना, कि somebody has obtained it from them, published it, and as soon as they got to know, they did not take any time and filed a patent application. So now if patent office will reveal any such document, they can simply give a proof that through lab notebooks, through various other means, that see, this is the instance that happened. This so and so came to me. He obtained the entire information from me, either as a friend or whichever way, and then finally published it without my consent. Provided also further that this inventor himself or anybody else, through whom, from whom, I mean, who through whom he claims, for example, the entity, the corporate, the employer, to whom the invention has been assigned. तो कोई भी हो सकता है. If the person has already brought it into the market in the form of commercializing it, and he has already worked it in India, then they will say, okay, then even if somebody has obtained it and published it, how does it matter? Because you were already commercializing it. So it was there in the public domain. There was nothing secret that you kept before you filed a patent application. It was already known to the world. So there is a provision to a proviso, है ना? तो such prior art documents will be considered as not the novelty destroyers if you meaning the inventor or the person who is claiming through him as the owner of the invention has not himself commercialized it before the priority date or before filing a patent application at the Indian Patent Office. Let us look at some hypothetical examples. For example, let's say Dr. Mehta, he invented a new biodegradable plastic. Before he filed a patent, a university librarian accidentally uploaded his draft research report to the university's public online repository. So in this case, Dr. Mehta's librarian, she obtained the information from Dr. Mehta because she is a librarian. She has to keep track of all the research that is happening in the university, but accidentally posts it on the public online repository of the university. So the effect would be that Dr. Mehta, when he files a patent application and this public repository is identified as a prior art, it will not be considered as novelty destroying because then he can prove that it was obtained from him. Of course, in this case, obtainment is not through fraudulent means. It was a simple obtainment as a librarian, but she ended up posting it mistakenly to the university's website. In the second case, consider Mr. Roy or Miss Roy. She invented a new agricultural drone system. and a foreign patent office mistakenly published part of her unpublished patent application due to clerical error. This can also happen. Let's say Mr. Roy or Miss Roy is filing it in US, but there are certain parts which were not to be published because she amended it. है ना? So provisional and when complete spec was filed. Um, so there could be cases which, where some parts were not to be prosecuted, but this got due to clerical error, it got published. So it was a premature publication, let's say, without her consent, which just happened mistakenly. So in that case, also such publication would not be considered as novelty destroying. Then section 29(3) is talking about where a complete spec is filed in pursuance of an application for a patent made by a person being the true inventor, true or first inventor, or somebody who is deriving title from him, and it shall not be deemed to have been anticipated by the reason only of that there is another application in respect of the same invention made in contravention of the rights of that person, or that other application which was made in contravention to the rights of that person, it was further what happened, used or published. ठीक है? So section 29(3) is the one which is talking about wrongful acts, fraudulent acts against the inventor, है ना, which were committed against the inventor by somebody. It's for example by theft, by breach of confidentiality, or by misappropriation by any assistant or employee. तो contravention of rights मतलब तुमने मेरे right को violate करके you filed what had to be filed by me. तो not only that you contravened my right, मतलब आपने मेरे से fraudulently एक तो you took that information from me fraudulently or through your wrongful act, and then it could also happen that you started to use or get it published somewhere. अब आपने पेटेंट एप्लीकेशन फाइल कर दिया and then you started using it in the market, and also you filed a journal article, let's say. So either of the things can happen. You file a complete spec by contravening the rights of that person, or you contravene the rights of the person and also you get it published and used in the market. So let us consider some situations. Suppose Dr. A had developed a new pharmaceutical compound. Before he files a patent application, one of his lab assistants leaks the details to a scientific journal without Dr. A's consent. हो सकता है इस lab assistant को बहुत सारा पैसा मिला हो भाई. Who knows? चलो, anyway. So this journal article gets published before Dr. A files his patent application. Now later, when Dr. A learns of this, he immediately files a patent application. And under 29(3), this journal will not be counted as a prior art since it was published without his consent. That means in contravention of his rights, and he acted highly promptly. And in another example, an engineer who developed a new circuit design, a colleague without authorization presented it in the conference. बड़ा अजीब colleague है who has done it. चलो. So the engineer, upon discovering this, files a patent application quickly. This presentation in the conference will not invalidate the patent, or it will not stop the grant of the patent application to receive a grant because it was an unauthorized disclosure in contravention to the rights of the true and first inventor. Another interesting example, there is scientist Kapoor. ठीक है, he develops a new antiviral drug. तो हमारे एक मिस्टर कपूर जो हैं वो हमारे बॉलीवुड के हीरोज भी हैं, बट यहाँ पे एक साइंटिस्ट हैं जिनकी हम बात कर रहे हैं. ठीक है, तो साइंटिस्ट कपूर develops a new antiviral drug. There is a disgruntled former employee who leaks the formula to a pharmaceutical magazine, which then further publishes it. So Kapoor files a patent application within a month of discovering this leak. And the effect is that this breach of Kapoor's right, which was done in contravention to his right, this publication in that magazine will not amount to be a anticipatory novelty destroying document. एक और last hypothetical example कर लेते हैं बड़ा quickly, that there is engineer Sharma who designs a new battery cooling system for electric cars. His junior, without permission, he presented Sharma's design at a trade fair under his own name. And Sharma learns about this a week later and immediately files a patent application. Effect of which that it led to being seen as an activity done in contravention of the rights of the of Mr. Sharma. So in this case, this will not be considered, this trade exhibition will not be considered as novelty destroying. I found these examples very interesting, so I utilize these for your explaining it to you. Conditions that you must look at is that if inventor becomes aware of unauthorized publication, but if he has delayed filing his own patent application for several years, then Section 29(3) protection cannot come to his rescue and he won't be granted a patent. There is also there could also be an anticipation by previous communication to government, but this will not be considered as novelty destroying because your previous communication to a government could be as a result of government funding that a university has taken or researcher has taken. Because there is a government funding, there is a public money involved, taxpayers money involved. So the inventor has to keep informing government about the progress of the invention, about the progress of the research, so that government can then take a bona fide consideration as to whether further funds could be released or not. So this kind of communication given to the government will not be considered as anticipatory. Anticipation by public display. So this is the section 31, which is extremely important like the other sections as well. This is talking about, this has four sub clauses, section 31A, B, C and D. In all four different situations are being covered. It might look like to be similar, but these are not. Let me explain it to you. Section 13(1)A is so this particular section is talking about exhibitions, displays. है ना, आजकल scientists जो है, आजकल क्या पहले scientists become very excited. The moment they come up with an invention, they'll immediately want to get it published in some journal article, yeah, display in some exhibition. So in 13(1)A, display of invention, है ना, in any exhibition which is notified by the central government. Agar to if he does that in such exhibitions which are notified by central government, then and within a grace period of 12 months he files his patent application, then this display in this exhibition will not be considered as novelty destroying. In B, in 31B, this is about the publication of any description of the invention in consequence of that display or use of the invention at such exhibition as aforesaid. तो जैसे एक inventor था, he exhibited his invention and also published that description of the invention or started to use it during that exhibition itself. Then that publication, post that display or use in that exhibition will not be considered as novelty destroying because he did so, number one, in the central government notified exhibition, and secondly, he immediately filed the patent application within a grace period of 12 months. But very important that you must, which is not written here in the presentation, but please mind it. Form 31. Please open up. You can pause the presentation here, open Form 31. That Form 31 must definitely be posted along with your patent application because in that Form 31 you are kind of telling to the patent office proactively as to where all did you already display it, which all central government notified um, what do you say conference this exhibitions, because if you displayed it, published it afterwards and then used it in any exhibition which is not central government notified, then even if you have used the grace period and filed a patent application, it will not be granted क्योंकि the rider is that it should be central government notified, and then you must file form 31 as I have stated, तो उसको please देख लेना. Now let's look at 31C, the use of invention after it has been displayed or used at an exhibition as aforesaid and during the period of the exhibition by any person without the consent of the true and first inventor. So basically it is talking about use of the invention by third party without the consent of the person who displayed it in central government notified conference. ऐसा होता है ना, आप भी exhibition देखने जाते हो and you get very interested and then you start using it, or so without the consent of that inventor. क्योंकि वो तो बेचारा he was just displaying it in a very very specific exhibition, that to very specific set of people. But आपने क्या किया? You went ahead and without the consent of that true and first inventor, you started using that invention. हाँ, market में आपने कुछ खरीदा, suppose आपने that invention was with regard to certain engineering product. आपने वो 10 खरीद के ले आए उससे कि बड़ी बड़ी मजा आएगा, इसको घर में यूज करते हैं, बट आपने उसको पब्लिक में यूज करना शुरू कर दिया है ना. सो इवन बिफोर दैट बेचारा कुड गो एंड फाइल अ पेटेंट एप्लीकेशन, यू स्टार्टेड यूजिंग इट इन द मार्केट. So then this usage will not become a prior art, or it will not be an anticipatory usage, at least novelty destroying, because then this inventor can show that immediately, within a span of, not immediately, but within a span of 12 months, he used a grace period and filed a patent application, filed Form 31 also. So he can say that so and so date I had displayed it, people had come, and that could have been the reason that it came into the public domain even before the priority date of my patent application. Last बड़ा important है 31D समझने में. The description of the invention in a paper read by the true and first inventor before the learned society or published with the consent in the transactions of the society. इसका क्या मतलब है? Read the three keywords: read before the learned society or published with his consent in the transaction of such a society. तो suppose करो एक science journal है ना? In science journal they host a inventors dinner, let's say. In the inventor dinner you read the description of your invention to all of them before the learned society. Now let's say you are presenting or you are reading your paper describing your invention to the learned society, which is, let's say you are a nanotechnologist. So people in the learned society would should also be nanotechnologists. A microbiologist, you can't say that that person is a learned society or member of the learned society. यहाँ एक जो chemist है वो learned society का part नहीं हो सकता. So you need to make sure that you read the paper, if at all, in association or in society, which comprised of only learned society members. If they were not, then this will become, this description of the invention and your reading out to them will become a prior art, even if you file it within 12 months, your patent application. Or it was published with your consent in the transactions of the society. So transactions of the society क्या होता है? Society में members come, they pay a fee, they become member, and in return they also get certain documents. So whoever is reading, whoever has presented their invention, their copies will be, let's say, circulated to only society members who have paid or who are the members. So that documentation should not have gone beyond the learned society members. So this is the meaning. So very very specific description of your invention read out to only learned society members in a society where society published it, that too with your consent, and made it available to the members of that society only. Then in that case, this circulation that has happened of the document will not become a prior art against you as novelty destroyer. तो ये एक इथाइल कॉर्ब, ये यूके के दो केस हैं जहां पे लर्नेड सोसाइटी का मतलब समझाया है, वेयर दे सेड दैट इट learned society has not been defined generally in the act, but it is not because it can be used, it has not been defined because otherwise it can be used to bring anything within the ambit, but merely because the legislator did not deem it fit to identify a qualitative threshold of learning. Because आप ये define नहीं कर सकते who could be the learned society member. There could be a PhD. Will you not call a postgraduate with 20 years of experience as a learned society member? So उसको define करना बड़ा मुश्किल है. So therefore it has not been defined. This is, I am talking about UK, and of course हमारे यहाँ भी defined नहीं है section 2 में. Now you look at transactions of the society. What does it mean? An essential prerequisite of a publication, if it is to be regarded as a transaction, is that it should be published under the auspices of and finally be the responsibility of the association, the learned society, whose organ of publication it is. ठीक है, तो ये थोड़ा मुझे लगा आपको मैं बता दूं. You can pause this and read it. Let's go ahead. Section 32, which is talking about anticipation by public working. तो ऐसा भी होता है कई बार that even before you file a patent application, you want to test your invention, कि whether it is working or not, and then take a decision whether you want to go ahead and file for it invest money, go to the market or something. So that working you do for the purposes of reasonable trials only. And there are few examples that I have listed here. You can pause the video and see it. But it is basically giving you examples of reasonable trial. जैसे somebody who has invented something, let's say a non-biodegradable pesticide, and he tests it on a small farm under the controlled conditions to identify the results. And then he files a patent application within 10 months. So this public testing is protected under Section 32. Similarly, for reasonable trial, let's say somebody has come up with a mechanical invention where he uses it on the buses. And it's a new braking system, powerful braking system. To check whether it is working or not, he tests this on some buses. So and then files a patent application within 8 months or within a span of 1 year. Now, this would not be considered as commercial exploitation. It's primarily used only for reasonable trial. So nobody can highlight reasonable trial or this trial as a novelty destroyer. Similarly, anything, any other invention that has been put to reasonable trial to just check it's working or not cannot become a novelty destroyer, provided 1 year time span grace period has been used and the inventor has filed patent application within a period of 1 year itself. Last, I think section 33, which is talking about um, which talks about that it prevents patents from being refused, revoked, or invalidated based on the prior use or publication of the same invention after the filing date of the provisional spec or the date of convention application. This provision ensures that inventors are not penalized if the invention is used or disclosed between the provisional and complete spec filing dates. इसको आसान करते हैं तो ये क्या है इसका जो लीगल लैंग्वेज आप पढ़ोगे तो दैट इज लिटिल बिट written differently but इसका मकसद क्या है what's the objective so the key point is that if let's say an inventor has already filed a patent application a priority date has been secured but he has not yet filed a complete spec because like we have studied in the class that provisional patent application never gets published. It's only the complete spec which gets published. So which means between the period of this 12 month um, priority application and the complete spec and after so a total of 18 months it will take for it to get published, the complete spec. Within the span of this 12 months, if you do some activity or somebody else does an activity of using your invention or you publish it somewhere else also after the priority date, then this particular usage or publication will not become a novelty destroyer because you have already been able to secure the priority date. Already patent office knows that you were the one who already had come to the patent office and secured the filing date and the priority date. So for example, let's say a provisional specification has been filed where Dr. Rao, he invented a new purification system. He files a patent application as provisional on 1st March 2025 and Scientific Journal independently publishes it or a similar method on 1st or 15th April 2025. So 1.5 months later. So this Dr. Rao's complete specification he filed on 1st July 2025. So, so, so this would be he would have an immunity against such publication under Section 33 because he can show that you cannot refuse or invalidate my granted patent because it was published by a journal because I already have a priority date earlier than that date. Similarly, there are two more situations listed. You can pause the video and check it. So basically, in order to cut the long story short, either whether after filing a priority patent application, the inventor himself, the patentee himself, used it in the market or published it anywhere else in, let's say, any journal, it is okay. है ना? Even if the patent application has not yet been published, because at least he has secured the priority. This act could have been done by even anybody else also. है ना? In a publication or use, maybe after filing a priority patent application, he might have told it to a friend who then had a, let's say, pharmaceutical magazine and he ended up publishing it. Whether with his consent or without his consent doesn't matter. But anything that is done post the priority date of the patent application, that activity of publication or use of that invention will not become a, uh, will not be used as reason for revoking a granted patent or for refusing its grant or invalidating a granted patent. So in a sense, Section 33 secures the filing date as the reference point of novelty, and any subsequent or publication cannot destroy the inventor's right. So it basically ensures that the inventor is not penalized for anything which happens between the provisional filing and the complete spec filing. So in summary, we have 29 to 34 as the exceptions to anticipation sections where we have just discussed quite in detail. You can look at it at your ease later once again. So any questions on anticipation that were asked in the previous year patent agent exam, I thought of just uh, showing those to you. In 2018, paper 2, a question was asked, question number 7 about Mr. Datta. You please look at it. Similarly, you open question paper of 2020 and you look at this question which where it says Manoj attended a fair, and then there is question number 2000 in the question paper 2013 also about Anjan who developed a drainage system, and then a 10 mark question. So these three that I just previously spoke about were 5 marker, and then there was also a 10 marker question that came in question paper 2011, which you can look at to see what other kinds of questions that may be asked. So with this, I thank you very much. I hope I've been able to explain this particular subject or the concept to you on anticipation well. Like I said, I am more than happy to always receive your constructive comments. Okay. If you wish to tell me anything that can be further comprehended, edited, amended, or you want to say anything as far as this topic is concerned, I would I would rather suggest that you come up now with a lot of MCQs on this particular topic to be able to appreciate the subject matter much better. And then, like I said, in class we again meet on Sunday, and then any queries that you may have, we will sort them out. Thank you.